Good morning, everyone. Welcome to the Center for Chinese Law and Center for Private Law Joint Seminar this morning. My name is Wei Xiaogu, and I'm a member with the Faculty of Law here. It's my great honor and pleasure to introduce our two very distinguished panelists today. First, our speaker, Professor Pippa Rogerson from Cambridge University Faculty of Law. Professor Rogerson is Professor of Private International Law at Cambridge, and then I think you don't need any introduction at all. Professor Rogerson is very well known in the field of private international law in the common law world. I should mention that she is also master of Gonville and Keyes College, the first female master in the history of this college. Today, she will speak on comparison of choice of law rules in non-contractual obligations between England and Hong Kong. We are also very honored to have our distinguished discussant, Professor Zhao Yun. Professor Zhao is the Associate Dean and Harry Jim Professor of International Law at the Hong Kong U Faculty of Law. Moreover, Professor Zhao is the representative of Hague Conference on Private International Law Asia Pacific Regional Office. Without further ado, let me invite you to join me, warmly welcome Professor Rogerson for her talk.
So thank you all very much for coming along. Thank you particularly to my dear friend, Professor Wei Xiaogu. I want to put on record my gratitude to her. She is an expert on arbitration and private international law, but particularly expert in giving a very warm welcome to people from the other side of the world. I'd also like to thank Louisa for all she has done. And later, I will thank Professor Zhao. While I'm doing thanks, here it is. I also need to thank Herbert Smith Freehills Kramer, the law firm, who are also in Hong Kong, who have funded my travels here today. They are very generous in funding travels for academics from Cambridge to go out around the world, and it is very good for us to experience law in the different parts of this world. Otherwise, we get very stuck in the old world. And so I thought I'd give you some pictures of the old world. Professor Hu mentioned that I was Master of Gonville and Keyes College. This is a college in the University of Cambridge. It's one of the bigger ones, one of the older ones, one of the richer ones. When I say old, it's 680 years old. So it was founded in 1348. And this picture on the right here is of the Gate of Honor, where our graduates go through with honor when they go to graduate, in the building just to the left of that picture, the Senate House. Just to the right of that picture is the original law faculty. Well, the law faculty since about 1900. But in 1997, we have a new law faculty, which is the picture, I'm sorry, not in great definition, on the left. And if any of you recognize the architectural sort of heritage of this building, it is the same architect as your airport terminal here in Hong Kong. It's a Norman Foster building. So we have moved from the old to the new. And in a sense, that's part of the discussion today, which is the old and the new sort of choice of law rules for non-contractual obligations. With England being an example of new rules and Hong Kong being an example of the previous rules. So I wanted to start with a little bit of an introduction for those of you who perhaps are not private international lawyers. I'm looking at choice of law rules today. These are the rules of the domestic legal system, which will determine which law, which system of law, which domestic system of rules will tell us the answer to questions that we might raise in our disputes. The question, is X liable? What's liable for? Has Y a defense? Those sorts of questions, we normally as domestic lawyers would say, okay, Hong Kong law will tell us the answer whether X is liable or whether Y has a defense. But choice of law rules are an abstract level a little above or alongside, by which we identify which system of domestic law will tell us the answer to those questions. Secondly, today I'm talking about non-contractual obligations. Non-contractual obligations is a very European concept. It is a category identified very much in civilian law systems, whereas in common law systems, we may talk about tort or torts. In fact, non-contractual obligations is broader than that, but let's not go that far. But it's not as, doesn't trip off the tongue quite as easily as tort, but it's the same thing. So if we were to look at, as I've mentioned, the English law rules are no longer the common law rules. They are found in the Rome II regulation. They are essentially derived from European law rules as part of the European law private international enterprise, whereas the common law rules are really what you have here in Hong Kong, and we're currently known as double actionability test. I also want to just give you my perspective, which is a methodology. Essentially, I am a doctrinal lawyer, a doctrinal private international lawyer, somebody who largely works in the commercial area. So I'm no good for family or crime or succession or any of that area. And indeed, in this area, we're talking about commerce. We're not so much talking about employment or consumers, which often have special protective choice of law rules. Now, I always start these sorts of occasions with a case study. Now, this is because I'm a doctrinal lawyer and because I think it gives us a context and a focus. So I'll have the case study on the screen. And just for the avoidance of doubt, Utopia is a fictional country with fictional legal rules. So just to quickly go through it. Say we have a Hong Kong resident, A, who is investing in a utopian Ponzi scheme. Well, you already guessed where the money is going, okay? A Ponzi scheme, one in which there is likely to be a merry-go-round and somebody loses out. And guess what? No spoilers, it's A. So A does this after B, also a Hong Kong resident, has misrepresented the financial position of the scheme, and there have been meetings about this both in Utopia and in London. Say the deposit, the money from A for this scheme comes from A's accounts in London, but the payments were made to the scheme's accounts in Utopia. I said A then suffers financial loss because the scheme all falls apart and wishes to recover losses, the damages from B, either in claim in deceit and or in fraudulent misrepresentation. These are non-contractual claims, okay? The contract claim is probably no good against the actual financial scheme because it is insolvent. Now, say, just to give us a little bit of a complexity, say that under utopian law, B's activity is criminal. He's made criminal misstatements and gives rise to a tariff of limited damages. There is a statutory scheme that says in these circumstances, the victim can recover this sort of money. And also say under utopian law, interest is not paid on these amounts. Now that's because I have another parallel research interest going on about how do we characterize payments of interest. We might not have time to get through that today. No, so that's our case study. So the questions, what are we asking? Is B liable? What for? These are classic choice of law issues. This is clearly a case with international elements in Hong Kong and Utopia and England. And we're trying to ask this question, what is the domestic law system which will determine the answers? Now, to get there, those of you who've done private international law before will quite readily say, oh, well, we must locate the tortious activity, we must locate the damage, we must work out what the types of damage are, what the heads of damage are. If we have a question about interest, what is the start date, what is the end date, what's the rate to pay, what's the proof of liability, is it strict liability, is it fault-based liability, is criminal liability sufficient, how do we deal with these statutory tariffs of law, and so on. Now, those are absolutely the right questions to ask. We could also ask, what's the relevance of the forum? All right, what is the relevance of the court in which this case is going to be brought? If A brings an action in London or in Hong Kong or in Utopia, should the court hear the case. Now, this is a total aside. Jurisdictional rules, at least in the common law world, are essentially discretionary, and therefore it's a normative question. But I want to raise in your minds the issue of the interrelationship between the court that you end up in and the answer that you get, because the choice of law rules may well be different between England and Hong Kong, between England, Hong Kong, and Utopia. Is it right that A can get a more advantageous result to A in one forum than in other? Because a more advantageous result to A is necessarily a more disadvantageous result to B. Now, before I'm going to look at the case study, let's look at the rules in general outline. So starting with the English law rules, this is the Rome II regulation. As I say, it's part of the European Private International Law Project. And this set of rules have become part of assimilated EU law as part of English domestic law post-withdrawal from the European Union, post-Brexit. We are post-Brexit, and I would just point out as my note, these rules are now free of the original underlying policy objectives. So the original objective of the Rome II regulation, along with other of the EU project, was to support the free market in the EU. And in order to support the free market, we needed common choice of law rules so that it didn't matter where you sue and that you could be clear about what result you would get from certain tortious events. Along with that, we had uniformity of interpretation of the regulation throughout the EU. We had references to the Court of Justice of the European Union, and these decisions of the Court of Justice were binding. Now, it's not entirely clear how removal of those EU elements will affect the English court's development of this case law. My guess is not so much. These rules themselves were pretty flexible. There is not a great deal of Court of Justice decision on these things, and I think we will just go our own way quite happily. So what are the rules? We start with Article 4, which is the general rule for general torts. There are specific rules, as I said, rules to protect consumers, employees, product liability, IP. There are some specific rules, but here I am just looking at Article 4, the general rule. And Article 4.1 says that the general law to be applied, the choice of law rule is the law of the country in which the damage occurs, irrespective of the country in which the event giving rise to the damage occurred, and irrespective of the country or countries in which the indirect consequences will occur. Now, this is what's known as a lex loci damni rule. It is not a lex loci delicti rule. We identify the country in which the damage occurs, but we do not look to the place where the event giving rise to the damage occurred, which is an alternative lex loci delicti. So we are going for where the damage occurred. We are looking for the plaintiff's loss rather than the defendant's activities. And we do not take into account where indirect consequences occur. So this is a narrow lex loci damni rule. Now, Article 4 goes on to say there's an alternative general rule if there is a common habitual residence between the plaintiff and defendant. So if they're both resident in Hong Kong, then you apply Hong Kong law, even if, say, the accident occurred on the defendant's yacht in Macau or Japan or somewhere like that. Okay, we would apply their common habitual residence. And this is a replication of a common law rule, actually, any of you who've worked in this area, in Boys and Chapman. The exception to double-actionability of Boys and Chapman was where there was a common habitual residence. No, these are two general rules in Article 4. Actually, the exception to both these general rules is where there is a manifestly closer connection with another law, a manifestly closer connection with another law. That law could be either the lex loci damni if you're in the common habitual residence general rule, or it could be a common habitual, one of the habitual residents of one of the parties, or it could be a third law. Those are all possible so long as you can show a manifestly closer connection. Article 4.3 goes on to say that this could be based, this manifestly close connection could be based on a pre-existing relationship, such as a contract. This is a possibility, but you have to show a manifestly close connection. So if we look at the English law rules, I've got some selected issues. One, to say that it's a deliberate policy decision to favour the plaintiff, to favour where the plaintiff suffered loss. If we think of what the purpose of this choice of law rule, it's really, we see in Article 15, to answer all the questions we'd asked about liability, remoteness, causation, damage, assessment, limitation, interest, everything. So this deliberate policy decision to favour the plaintiff is to focus on the plaintiff's loss rather than the defendant's conduct. Now, if we unpack a little bit where the damage occurs, this favouring for the plaintiff, generally for personal injury, that's where the accident happened. It is predictable, it is clear, it is something that both parties can tell in advance. But it can be a more complex calculation. If you're not talking about personal injury, or even in some cases on personal injury, you can have more complexity about working out where the damage occurs. So, for example, what about secondary victims or parasitic loss, vicarious liability, joint liability, and so on? Where is that damage occurring? Well, the case law has told it is where the initial damage happened, the initial damage for personal injury. So if you are somebody who has suffered nervous shock because you've seen your child has been injured in a road accident, but you were in England, they were in France, the initial damage was in France, Lazare says that you go to France, the place of the initial injury. So it is a sort of predictable and certain place. And it is not where the indirect consequences occur, for example, where the plaintiff returned to their home country to suffer their medical expenses, their loss of income, and all of that. Those are indirect consequences of the initial damage, and therefore the law to apply is not that later law where you've returned home, but the law of the initial damage. That's the effect of location in Article 4.1. I've mentioned the common habitual residence exception. That becomes then a very critical concept in cases where you have both parties common habitual residence. You will find that defined for corporations in Article 23, the place of central administration, or the branch, if it is the branch that is the branch of the parent office that is responsible for the conduct. So place of central administration, not place of incorporation, not principal place of business, central administration. That's defined in Article 23. For individuals acting in the course of business, it's your principal place of business. Okay, that's clear. For natural persons, individuals, not uncommon in tortious cases for individuals to be the defendant or the claimant, no provision, no definition. And there's very complex case law across the EU to identify your habitual residence. Anybody who has worked in domicile of natural persons will also know that there is very complex case law, and it's the same problem. Where is your home? For many of us, not a problem. For some of us who are more peripatetic, it is a complex question, and there's no definition in Rome 2. There's some EU case law, it's quite complex. Is it, for example, unclear if you can have more than one habitual residence, but it's a very critical concept. Okay, moving on down the slide, manifestly closer connection becomes another critical concept. And we can split it really into these three areas. The first, very interrelated to the second, is what is the threshold in order that this exception will bite? All right. What does a manifestly closer connection have to cover, leap over the hurdle, the threshold for this before it works? Now, there has been a fair bit of discussion about this. It depends on whether you think the general rule of the lex loci damni or the common habitual residence should be strong, or whether you think it should be easily overcome. And this is actually a discussion that runs throughout choice of law in tort. We'll see it. It also works. It also has operation in the double actionability test. Should it be a strong general rule or a weak general rule? If it's a strong general rule, you have more predictability and certainty. If you have a weak general rule, if it's easily overcome by identifying another manifestly closer connection, more significant relationship, close connection. If it's easily overcome, then we are in the area of flexibility, maybe doing justice, but we are very much with the possibility of the US experience. Now, any of you looked at US experience in choice of law and tort will know in the 1960s, they started off down interest analysis and the way of trying to resolve this tug between the claimant's loss and the defendant's regulation by looking at the interest analysis of the rules, the actual domestic law rules. Now, what that did throughout the 60s, 70s, 80s, and beyond is being described by a famous American law judge as conflict of laws being a dismal swamp, inhabited only by mad law professors, because nobody else can understand it. Great flexibility, but terrible uncertainty, the dismal swamp. And certainly European choice of law lawyers are terrified of the dismal swamp, apart from one of my colleagues. One of my colleagues has pointed out that the primeval ooze, the dismal swamp, is the place where real creativity happens, and that we should embrace the dismal swamp because that is where we will get good choice of law rules. In practice, a commercial lawyer like me, I'm going, oh, I'd like to be able to advise clients a little bit more about how they can identify their possible liability than having to go through the dismal swamp of the mad law professors and indeed the US courts. But anyway, so one, we have to ask, what is the threshold? How strong is the general rule? Secondly, we have to identify what the significance of the factors are. How do we evaluate them? How do we weigh them? Do we just count all the contacts and put them into a list, or are some more substantial than others? And thirdly, what is the value of the pre-existing relationship? Is it a strong thing to give you a manifestly closer connection or not? There are, as with any conflict of laws area, there will be an exception for public policy. For those of you who are not private international lawyers, not conflict lawyers, these are international policy concerns, and these exceptions are very rare in practice. We will also have mandatory rules in the forum, which can overwhelm the choice of law process, but check that your local mandatory rule really does apply in scope and covers this particular case. Now, I just asked the question, does the choice of law rule apply for one tort or a single issue? For Rome 2, the answer is the whole tort is subject to the same law. Not quite so clear in other double actionability cases. Now, moving quickly on to Hong Kong choice of law rules. You have our previous common law rules on double actionability. And these are now relatively uncommon in the common law world. Singapore has double actionability, Caribbean states have double actionability, but Canada and Australia have moved to a different system. England, of course, has gone to this EU system. And for what I understand about mainland China, and I'll digress very shortly because I am not a Chinese lawyer, I will defer to people who know much more about the language and legal culture than I do. But from what I have seen, Article 44 of the law applicable to foreign related civil relationships from 2011, the law applied is the place of the tort, which is either where the claimant suffered, the plaintiff, suffered damage or where the defendant acted. Now, that's not a great choice of law rule because it's double, either or. Right? And there is an exception for the common residence of the party. So in some ways, rather similar to the private international rules in England. In outline, it looks rather similar. It's not obvious that there is a flexible exception, but I have found a few articles by somebody local who you may know, Zhen Chen, and excuse my Chinese pronunciation, on the British Carnival Cruise Line case in the Shanghai Maritime Court. So that case appears from these articles to me to show that there is a most close connection exception, although that's not in Article 44 itself. It is part of the principles articulated in Article 6. And that's as far as I go. Right. So Hong Kong double actionability in a little bit more detail, and you probably know this, so I can whiz through it. You apply the lex fori. Let's assume this is Hong Kong. We're in a Hong Kong court, and therefore that will be Hong Kong law. And we will say, does the plaintiff recover under Hong Kong law? And also we ask, is there civil liability by the lex loci, which is the place where the tort occurred? A broader concept than the place where the damage was suffered, a broader concept because it incorporates also perhaps the place where the defendant acted, where the events happened. Now, I will try not to say claimant, but I have spent the last 25 years trying not to say plaintiff. Lord Wolfe might just go to claimant, which I really don't like, but I will try to say plaintiff because it's the same thing. Okay, so double actionability, subject to a flexible exception. It is possible if the plaintiff does not recover under that double actionability test to allow the plaintiff to recover where particular issues between the parties or the case as a whole, we can apply the law which has the most significant relationship with the occurrence in the parties. The most significant relationship with the occurrence in the parties. And this has most recently been looked at by the Privy Council case of Credit Suisse and Ivanishvili in 2025, UKPC 55. Now, this is a case on appeal from the courts of Bermuda. No, the facts are that there was a very complex fraud and it was perpetrated by an employee of the defendant, Credit Suisse, and he basically stole the money of the plaintiff, Ivanishvili. So Ivanishvili, who is a Georgian resident, brought a number of claims in the Bermudan court. Now, but here I want to concentrate on the choice of law aspects because there are a number of other aspects in deceit and misrepresentation that you may be interested in, but I'm only interested in choice of law for today. Okay, so the defendant's argument was that the defendant employee's misrepresentation was not actionable under the Lex Fori, under Bermudan law. That was their first argument. And Lord Leggett, who gave the opinion of the board, went on a long disquisition about whether English Bermudan law of deceit and misrepresentation indeed gave rise to liability. And in the end, decided that, in fact, the defendants were wrong. The plaintiff did have a case that was actionable under Bermudan law. So that was that. It was liable according to the Lex Fori. But was there also liability by the Lex Loci? Now, for now, just note that the parties had agreed that Georgian law was the law of the place where the tort occurred, right? That the tort had occurred in Georgia. And therefore, this question, where did the tort occur, was not in dispute. What was in dispute, there was no liability under Georgian law. Why was there no liability under Georgian law? Because the statute of limitation period of 3 years had passed. This fraud actually went back well into the early 90s. It was really a very long-running fraud. Okay, so the plaintiff could not satisfy the double actionability test. There was no liability under the Lex Loci. Well, was the flexible exception available? Was there a law with the most significant relationship with the occurrence in the parties under which the plaintiff could recover? Now, in applying the exception, we do a rather similar analysis as I've just talked about under the Rome 2. We have to ask ourselves, what's the threshold? When does the flexible exception kick in? All right. Is this exception available? Now, Lord Leggatt followed Sophocles and the Secretary of State for Foreign and Commonwealth Affairs in 2018, an English law case in the Court of Appeal, where he said that the width of the flexible exception was not defined. But it should not be too readily available, i.e., there should be some weight in the general rule. Indeed, taking Boyce and Chaplin's words, he said, we should apply double actionability unless clear and satisfying grounds were that it should be departed from. He then went on to say something that's actually even stronger. He put it another way, following the Eastern Caribbean Court of Appeal case of I-Management Services and Kukarova in 2008, to say almost all of the significant connecting factors must point in the direction of the most significant relationship. All or almost all. Now, that is a very strong weight given to the general rule. It means if you have any factors in favor of the general rule, you can't use the flexible exception. So, looks like you've got to have quite a little connection with the general rule and a strong connection to the most significant relationship. So what factors did he take into account? No, he did not identify the law with the most significant relationship. He did not have to, because he asked the question from the other end. He said, in effect, was the lex loci, the law of Georgia, to be displaced? Having said that the general rule was strong, having said that in order to apply the exception, almost all of the factors had to point to the significant relationship, then it meant that he was really asking, were there enough factors connecting it to Georgia in order not to displace that law? And if you look at the events, there were plenty in the case, there were plenty of significant factors connecting these events to Georgia. And indeed, very few connecting them to Bermuda, which was the law that he was trying to argue for. Ivanishvili, the plaintiff, was resident in Georgia. The corporate vehicles which were used to perpetrate this fraud were incorporated elsewhere in the Caribbean. The policies were signed in Georgia. Credit Suisse was signed in Switzerland. The policies were issued in Switzerland. The fraudulent representations themselves were made at meetings in Georgia. So we can see fraudulent misrep in Georgia, plaintiff from Georgia, money came from Georgia. The fraudulent conduct was not done in Bermuda. The loss was not suffered in Bermuda. The fraudulent agent and all the bank's employees were in Switzerland. There was enough connection with Georgia. There was very little connection to Bermuda, other than that was where the defendant was incorporated, and plenty of connections with Switzerland. So Lord Leggatt said, not a case for the exception to apply. And if you look carefully at the incorporation, at the defendant, the only real connection with Bermuda was a letterbox incorporation in Bermuda, i.e. that the company which was liable, Credit Suisse Bermuda, was incorporated in Bermuda, but did not really operate there. It was a vehicle for being able to take advantage of the tax and rather lax regulation of companies in Bermuda by Credit Suisse, largely a Swiss-based company. So the connection with Bermuda was very, very slight. And although the policies were governed by Bermudan law, the policies through which Mr. Ivanishvili had invested in this scheme were actually governed by Bermudan law, Lord Leggatt asserted, discussion about this, that he could not see why the governing law of the policies was relevant to the claim made in misrepresentation. Now, I wonder about that. I haven't gone to look at the first instance case about the actual wording of the choice of law, because I think it's possible to make the governing law in contract relevant to the question of the significant relationship. I think it's possible, but as far as Lord Legate was concerned, it was not. Now, on the result, it's a bit of a shame that the plaintiff did not recover. On the other hand, that's the point about limitation periods. You must bring your action in good time. He can hardly complain about the fact that the Georgian law of limitation applied to his action. He was from Georgia. The outcome is entirely, it would have been predictable to him, it would seem to me. But things are always better with hindsight. But any of you who are going into practice, limitation periods are the thing you really, really, really have to watch. Really have to watch. Okay. Now, we could do some quick criticisms of double actionability, just in case there is any pressure on the Hong Kong legislature to think of abandoning double actionability and taking on, maybe following what's happening in mainland China in their law, which has been in place now for 15 years, or England or Canada. Don't follow Australia, please don't follow Australia. Well, for those of you who know, Australian choice of law rule for non-contractual obligations is the lex loci with no flexible exception. Absolutely no flexible exception, which has got them into terrible trouble. They started using renvoi and all sorts of really very, very unnecessarily different ways to escape the problem of too fixed a choice of law rule. So don't take a too fixed choice of law rule. So why double actionability was criticised very much by Lord Legate, indeed, in the Credit Suisse case. He said, nobody has made it possible for me to, that they've not argued about an alternative choice of law rule, and therefore I make these criticisms, but I can't make a different choice of law rule. So maybe that door is open, but there are criticisms of double actionability. Partly because it's anomalous to have two additional laws, double actionability, make the claimant satisfy two different laws. The claimant loses if even one of them says there's no liability, as in this case. It's said to give an unfair advantage to the defendant. Secondly, it's parochial. In effect, the choice of law rule is the lex fori, the law of the place in which you end up in court. And that happens even if there is no or very little connection with that court. And that for private international lawyers, for conflicts lawyers, goes against principle. We say that where you end up in court should not have that effect. And double actionability with the exception is possibly unpredictable. It's said to be very claimant friendly, although here we are in Credit Suisse, the claimant did not succeed. Okay, now, I think we don't have time to go through the case study. We can have some questions. People can ask me. In conclusion, actually, what I'd say, having worked through the case study, is there's no real distinction in result. We can get very much to a similar result, the same result, irrespective of these two choice of law rules. They will both turn on the flexible exception, whether it's a manifestly closer connection or whether it is the more significant relationship. The complexities for both will arise on where you think the place of the tort is, whether it's where the claimant suffered the loss. In financial economic torts, it's very flexible. You have much opportunity to identify one or another place of the tort, depending on where you would like to get a result. Generally, I think it's possible with both sets of law to manipulate the place of the tort to identify where you think the lex loci is, whether it's lex loci delicti or lex loci damni. I think the flexible exception works in a similar way, quite a high threshold now, post-Credit Suisse, and quite a high threshold we know in Rome 2. and we have a similar weighing of factors, I think we would end up in a very similar result. So, short answer is, I don't think the case studies, you'd work through them differently, but I think you'd come to a very similar result, because at heart of the difficulties of non-contractual obligations and choice of law is this tussle, this competition between where the defendant acted and where the claimant suffered the loss. If these are two different places, your choice of law rule is having to choose between one or the other. And this is apparent through the American Dismal Swamp, through double actionability, and through the post-double actionability legislative solutions. That the choice of law rule, in a sense, is having to make a choice between these two policy objectives. And European, at least, have been explicit about choosing the claim where the claimant suffers. For good or ill, that law may not be as advantageous to the claimant. There's no necessary reason for that law to be as advantageous to the claimant as it wasn't in Credit Suisse. The plaintiff's law was not advantageous to Mr. Ivanishvili. He lost under that law. But it is this choice. And so at least flushing out that is a choice is, I think, a thing worth doing. Well, that's my 40 minutes. Thank you very much.
Thank you, Professor Rogerson. Well, excellent. I mean, I learned a lot from your presentation. And then I think I do agree with you that EU law is very predictable. In the sense that, you know, it's not really whether it's more advantageous or less advantageous to the claimant. It's very predictable. Now, let me turn to Professor Zhao for the comments.
Thank you, Weixia. Thanks to Professor Rogerson's excellent presentation. I think really for myself, I also learned a lot. I think at the international level, I think when we look into the private international law, we normally look into the three major areas. I think jurisdiction, choice of law, and recognition and enforcement of foreign judgments. And in recent years, we also look into the fourth areas of cooperation. So I think if we look into the work of the Hague Conference on Private International Law, all the conventions that have reached, we focus on these four areas. But when it comes to the choice of law areas, we can see that top areas, all the non-contractual obligations areas, proves to be very complicated. We have already, in 2015, we have already have the international commercial contracts. We have all these kind of choice of law rules already. But for top areas or non-contractual obligations, we found out that they are quite diversified. Now, if we look into the various areas, I think in particular, look into the transnational litigation and cross-border enforcement areas, we found out that actually the European Union has been moving ahead very steadily. For example, when we look into the project on jurisdiction, we found out that EU actually is very powerful, I think, and the leader, I think, in moving ahead. Although we can find out the jurisdiction project isn't, we should be pessimistic. Last week, I think the member states have already decided to wait and see. So that means we will not continue with the final convention. But anyhow, I think EU has done very well. When we move into the Hong Kong side, as Professor Rogerson has mentioned, double actionability rules has been applied for many years, but we can find that the international trend is quite clear. This has been replaced in Canada, Australia, and many other jurisdictions. Of course, Professor Rogerson also mentioned about the flexible exception. I think that's really important. But what will be the high threshold? I think that could be very interesting to see. I think when we look into the case studies, I think what will be the threshold? This also leads to the issues of uncertainty. So that's rather difficult. I think in the last few years, there have been also some discussions about other possible approaches to deal with the choice of laws issues. One is regarding the proper law, which means that we are trying to use a law with the close, significant connections with the chains of acts and consequences in a particular situation. Of course, I think normally this kind of type of law should be the law of the place of wrong. But again, I think this also leads to some uncertainties and complexities. Some scholars have mentioned the proper law approach is academically ideal, but practically impractical, I must say. So I think that's one approach which has been discussed. The second one, I think exactly, is a Rome II regulation has put forward a law of the place where the wrong is committed. But in a way, I think it's quite clear, it's certain. But also we can find out that first, that's exception also. So which mentions that if a person claiming to be liable and this person sustaining damage both have their habitual residence in the same country at the time when the damage occurs, the law of the country should apply. So that has been put on in the Article 4, paragraph 2, I think, for after the general principle. That one aspect. The second aspect, there are also some exceptions in the EU regime, I think, when it comes to defamation. The UK or other countries probably can have some flexibilities in using other choice of law rules. So that's a second. But we admit, I think this the second approach has been widely used. It, as a moment, has been widely used, I think, not only in the EU, but also in China. I think so. I think that's very important. The third one, I think I wouldn't say this is very important or not. I think that's the most favorable law. So that means we will choose the law of the place that is the most or more favorable to the injured party. So this has been put forward, but if we look back to the history, I think Germany for some time adopts the most favorable law approach, but in 1999 has been abolished already. There are also some advantages and disadvantages. They said, I think, what kind of law will be considered to be the most favorable law? So there are several factors to consider. For example, the amount of damage to be obtained by the plaintiff. I use a plaintiff. And then, of course, the likelihood of success in obtaining the remedy. So I think there are several factors to consider which law will be more favorable to the plaintiff. In that sense, in a way, I think we are trying to use a law chosen by the plaintiff in a way. So is that fair or not? There are also some discussions. Probably there should be some limitation. So for example, the law should have some legitimate connection with the case. So there are some discussions. I went through some articles. Some scholars have also argued that probably in Hong Kong, we should also adopt the most favorable law. I'm not sure, I think, whether this will be good or not. But I must say the choice of law in the top areas, there's no fast solution. I think that's no ideal situation. The most important that we should try to strike a balance. That means I think there are various factors in place. Whether we will continue to use a double actionability rule, or we probably adopt the law of the place where the wrong is committed. That I always think there should be some flexible exceptions, no matter if there's a high threshold or low threshold, at least we have some exceptions. So I think I probably will stop here, so to reserve some time for Q&A. Thank you very much.
Well, thank you. If I could just take a couple of minutes in response. No, the most favorable law to the plaintiff, the injured party, let's say the injured party. I don't know whether negative declarations are possible in Hong Kong or not, but they are, which switches the parties around. So the most favorable law to the injured party, I think, risks incoherence because they can pick and choose between the issues. I suspect it's not predictable to defendants. And when we talk about predictability, wearing my commercial hat again, why is predictability important? It's important because the defendant does not know how to regulate their activity, as in not regulate as in government regulate, but decide how to act in advance if they do not know what the likely consequences of their activity is going to be. And therefore, the predictability is important for the defendant to be able to identify what the consequences of their actions and activities are going to be. And predictability is also important for that reason for insurance. And insurance is very significant in tort, being able to insure your activities. An insurance company needs to be able to price insurance as a consequence of the activities of the defendant. And in order to do that, needs to be able to price in what the likely law consequences are going to be. Now, within the EU, that became very important for the paradigmatic, for us and the US, paradigmatic choice of law in non-contractual obligations case, which is the car accident. Yeah. The other one would be product liability, but I set that one on one side. But you know, it is that A and B get into a car, have an accident. A goes to France, knocks over B. A, you know, those are the most common tort choice of law cases. And being able to identify the law that will govern those cases is very, very important for car insurance companies. So we need coherence and we need predictability. I just suggest that. And that having some sort of ex post facto after the event's choice, where the plaintiff chooses either which forum to end up in or which law is likely to apply because it's the most favorable, might have unintended consequences on those two other things that I would say. So absolutely. I would also entirely agree with you about balance. And that's where I think the threshold becomes important. Should the general rule be reasonably strong? And for personal injury, the general rule is very strong. The place where the accident happened is very powerful in our experience in the cases that we have had. It is predictable, it is clear, both parties, the person who has injured the party and the injured party are quite likely to intuitively consider that that should be the law. Yeah. So for the paradigmatic case, in the usual example, the law of the place of the accident is very strong. Where we need more flexibility, perhaps, or the cases arise, is where either there is little connection with that place, and that's where common habitual residence tends to come in, because again, the paradigmatic American case, there is a pre-existing relationship in the common habitual residence, husband and wife, father and son, two friends, getting into a car and going somewhere and having an accident. And then you can see the predictability of the place of the accident sort of falls away because it could have been France, but they could have gone over the border into Germany. There is less, the place of the accident has less strength. Okay, so we need a flexible exception, and we can understand circumstances. It's when we move to economic talks that it's much, much, much more difficult. But we still need insurance. Employers still need to be able to know how to control their employees, what's the liability they're likely to have when their employees go off on some frolic of their own. So absolutely. Defamation, libel, yeah, all bets are off because the policy considerations are so much, they're very different. They will be in freedom of speech, regulation of the press, reputational damage, all of that, which feels essentially more territorial, which is ridiculous given that I could be libeled on the internet in America tomorrow. And no, I would not. My advice to my students is never, ever, ever take a libel action. You only make it worse. Whether you're right or not, it ends up in the court and everything is out there. Everybody knows everything about it. We've only got to think of the Wags case, the Collier case. Nobody wins, except the lawyers. They make money. So absolutely, but I've spoken enough. Anybody else have some questions for us?
We start slightly late today, so I think I can use my chair privilege to postpone the session a bit. Let's say 5 to 10 minutes. Maybe we can take 2 questions. So the floor is open to the audience. When you raise the question, please identify yourself as well. Thank you. Yes, Professor Zhu.
Thank you so much, Professor Rogerson. I'm Ying, I'm an assistant professor here at Hong Kong U Law. So I have a question about the public interest exception or public policy exception. So I know in recent years, there's a lot of uncertainties in the world, and the states are increasing their compliance requirements. So do you see a expansion of the scope of public policy exceptions in recent years?
Why don't I just reply to that? Because it's a little left field. I mean that in a good way. So public policy is an exception to choice of law rules. Generally understood, you'd say, okay, the choice of law rule says apply the law of utopia, but we're not going to apply the law of utopia in this case because there is some public policy requirement. Now, how would that work in the law of non-contractual obligations? We'd be saying there's some overarching international public policy requirement of, say, Hong Kong law, which means that we treat that utopian rule as beyond the pale. Now, sometimes it's happened in contract cases with sanctions, where the public policy is very often actually firmed up in local legislation. And yes, when it's local legislation, you say it's a mandatory rule. You know, you don't use the public policy gateway, you use the mandatory rule gateway, and you say, okay, yeah, well, Hong Kong law says that we can't enforce whatever contract it is, or there's no liability. It has been used in a more positive way in some, it's not quite coming through yet in England, to provide a remedy for torture. So say the plaintiff has been tortured in utopia, say utopian law says no liability against state actors. So it's not unusual, actually. State's not responsible for torture. Maybe the general is, but the state is not responsible. And we are now seeing cases in which the English court has started to say, quite got to judgment yet, yes, we will ignore that Saudi Arabian law. Sorry, I shouldn't mention. We'll ignore utopian law, which gives no liability, all right, on public policy grounds. But those are vanishingly rare. We'd say they're for use cogens reasons, discrimination on the grounds of race, religion, or gender, and probably torture. Now, we're finally seeing a few of those. So in a way, it works in a slightly more negative. A traditional public policy exception is a negative application. We won't apply the choice of law, applicable law. We will apply the local law. Sorry, if that answers.
Maybe, yeah, the gentleman first, and then Craig.
Hello, I'm Ivanishvili. So I'm a PhD researcher at the University of Antwerp, Belgium, and I'm also member of membership committee of Silicon Valley Arbitration and Mediation Center. So I have a question regarding financial assets, but those are digital, like crypto assets and all kind of things. So if our case, if we couldn't trace back all the banks and all those procedures, would the only thing and the thing we would base where the victim is located, and when we understand the victim, should we look the victim is that where victim lives? Because sometimes the laptop or the cryptocurrencies may be in devices where it's different than where the victim lives.
Yes, you've articulated very well the complexities of locating factors. All right. Yes, the habitual resident, common residence of the parties may be in those sorts of cases less relevant, less significant, less strong. But so in those cases, also the location of the assets is almost ephemeral, as far as I understand, where a crypto asset can be actually located on the blockchain. The blockchain is not physical, as far as I understand, a physical existence. And And so this is a real challenge for private international law across the board, not just here, property, regulation, all sorts of things, where we depend on actually locating factors. Some of these very important factors are not capable of physical location. They may be capable of something close to physical location, not crypto, as far as I understand, which is the law or system of regulation which creates them. Maybe. But, both the victim and the defendant may well be peripatetic. They're a digital nomad. They don't have particular, and that's a problem with habitual residence as a concept, but for the great majority of us. So I agree, you've identified a particular issue, which is at the moment unanswerable. Does it have to be answered, or do we just say none of those factors are significant? We have to look to factors that we can locate, or does that end up with some real unreality? I don't know. It's a good question.
Thank you for an excellent talk. I'm Craig Pearshouse here in the law faculty. I'm quite ignorant about conflicts, but my question is, with the double actionability rule, it might seem a bit harsh if the law of the forum doesn't seem quite appropriate. Do you think this, I get that the jurisdiction and the choice of law questions are different, but do you think this might have been, has this been heightened at all by a more generous approach to jurisdiction after like the Brownlee litigation, or not? It's just
well, yes, and I could spend a while criticizing the Brownlee litigation at many levels, not least that we had to go to the Supreme Court twice to determine an issue of jurisdiction. I mean, that's just scandalous that our jurisdictional rules require that. I mean, absolutely shocking. But the interplay between jurisdiction and choice of law, absolutely. I think we often overlook the necessity for these not to go hand in hand, but for the choice of law rules to be not dependent on wide jurisdictional rules. And this was raised by, and answered by Lady Justice Arden in a case called Harding and Wellens, actually a tort choice of law case. And Lord Hoffman went, he could not see, in the same case, in the then House of Lords, he could not see the problem with forum shopping and choice of law rules. So unfortunately, when you have Lord Hoffman saying something like that, everybody goes, oh, doesn't matter. But we keep going, no, Lady Arden was right. She was right. So you're absolutely, it is absolutely a concern, and I have a concern about Brownlee. We can talk about that later.
The time is up. Well, it's a wonderful talk. We thank Professor Rogerson, and then also we thank Professor Zhao for our two very illustrious panelists today. Can I invite all the audience to join me in thanking the two wonderful speakers? And then please stay tuned for the activities of the Hong Kong U Faculty of Law as well. Thank you.